you, Matthew. Anybody else have problem parking today? That was great. Thank you very much. Wasn't my fault. Oh yeah, please. Okay, so I'm not going to be very long because I want to get out of these guys' way because we've got some great speakers here today. So I thought I would just recap what we talked about a little bit last time. And what we did is we sort of covered the basics, or we tried to cover the basics. And we talked about the Oregon Medical Marijuana Act. And I think that some of the things that to take away from the circumstances now are that I know that a lot of people, a lot of brokers, a lot of people have concerns about getting into this industry. But one thing to keep in mind is that medical marijuana has been around since 1998. So I included some fun facts there about what you can and can't have. I'm not going to rehash those. I think we'll have this PowerPoint available for people. But I looked up the Oregon Medical Marijuana Program on the internet. They have a website. And as of April 1st, there are over 71,000 cardholders in Oregon. So one of the concerns that we always have is, well, gee, what's the next administration going to do? Is the federal government going to change its mind on what's okay and what's not okay with medical marijuana? But the fact is, in Oregon alone, there's 71,000 people with cardholders. So if you're going to turn them away, I'm not sure if that seems likely or not, but that's something that would need to be dealt with. There's over 1,600 physicians that are involved with medical marijuana as well. And again, this is just in Oregon. Another thing we talked about last time is I think there's 25 or 26 states that have medical marijuana, including the District of Columbia. So in other words, Congress is surrounded. So if they want to change something, they may have a problem with the folks outside. I don't know about that. So we also talked about the Cole memo, and the reason I'm bringing this up again is that's kind of the guiding principle. Those are the guiding principles for what the federal government is concerned about and what they're not so concerned about. They're concerned about everything. Marijuana is still illegal. It's still a Schedule I substance, so don't worry about that. If you're worried, it's illegal. But the federal government has said that we are going to list for you our priorities. We're going to focus on those, and so if you're involved with a cartel, you will be in trouble if we can catch you. If you're selling marijuana to minors, we will try to catch you, and you will get in trouble. If you're selling across state lines, that's another no-no. And there's a variety of factors. Those are the main ones. So the Cole memo is something that we want to think about when you're dealing with clients or people in the business that you're not too sure about. If you can do your due diligence and find out what they're up to and get information, you can then see whether the Cole memo factors are implicated. If they are, you probably don't want to get involved in that transaction or that business. But if they're not, and if they're coloring within the lines and following whatever state laws there are, then you're probably in much better shape. We touched upon Measure 91. We were privileged to have Dave Kopelak last time, and he was one of the authors of Measure 91, so he could really give us a scoop, and that was helpful. I've included some fun facts about Measure 91. The funny thing about 91 is that July 1, 2015, marijuana is legal within those limits. One of the challenges is, and what Mr. Chapman I think is going to talk about, is that it's still not legal to sell it. So you can't sell it, but if you acquire it, you can have it. So good luck with that. And then we talked a little bit about the risks and benefits, and Margie Elkin did a great presentation on leasing. So I'll cover that a little bit. She talked about the risks, and we've already talked about how, oh, by the way, it's still illegal. And some of the risks are as like say a landlord. If your client is a landlord, they can be at risk for aiding and abetting with an illegal business activity. There's also the danger of civil forfeiture. If the feds come down on you and you're a property owner, they can take everything. And when I say everything, then I mean everything. And there's also co-tenancy issues. Margie advised to contact your lender if you're a landowner or a property owner. because violation of federal law can leave you in breach of your loan covenants, and your loan can get called. And so that's a bad day. And you also want to check with your insurance broker, look at your policy if you're a landowner. There's co-tenancy issues. Marijuana has a very distinct odor, and it can sometimes attract the folks that you don't want to attract, which also reminds me that medical marijuana dispensaries in Oregon, by regulation, are required to have security. You're required to have cameras, alarms, a vault. You're supposed to keep the good stuff under lock and key, and the regulations define what a vault is, what a safe is, very specific construction requirements for security companies, and you got to have those if you want to be a dispensary. I didn't see any rules about grow operations, but if you don't have security for a grow operation, I think that you're making a big mistake and taking a big risk, too. The benefits are, we know that the tenants tend to pay better rates, as I understand it. And frankly, from what I understand, a lot of the tenants, for example, the warehouse tenants that have a grow operation, they don't want attention. They don't want to be around, they don't want to be close to schools, they can't be close to schools, they don't want people coming around, and so they're going to be quiet. They're going to behave pretty well, or at least they should. Does that sound about right? Okay. This is my answer man right here. And then finally, Bob Nelson asked a question that we didn't have a really good answer to last time, and that was very simple. Can anything bad happen to us, happen to a broker if you engage in a marijuana business? Great question. We didn't have a good answer for that, and I'm sorry about that. Well, luckily, Connie provided a memo for us. So I'm just going to sit here and read the memo. So paragraph 1, no, I'm just kidding. But read the memo. I haven't had a chance to look at it in detail, but that's exactly what you guys need is some guidance because it's hard. Again, we're dealing with an illegal activity. So in addition to that, we did some research. And when I say we, I mean my associate, did some research, legal research, to see how many brokers have been convicted of anything in connection with a drug dealer, some kind of marijuana business, and we couldn't find anything in Oregon. So to our knowledge, there's no cases in which a broker has been found responsible or liable for aiding and abetting, money laundering, that kind of thing. But we did find, excuse me, a case from Iowa, and it's called United States versus Cooper, and I'd be happy to provide copies to anybody. I kind of like reading it because it's sort of a how-to of how to screw it up really badly and get caught and convicted and sentenced. So the things I'm reading, don't do this. So this broker assisted a client with a real estate purchase, and she was convicted of aiding and abetting a money laundering scheme. And so when she was approached by agents, she really spilled the beans. So she told the federal agents that she knew that her client's lifestyle was probably not legitimate because of his expensive clothes and cars. She had not been sleeping well. She told the agents this. She knew that her client was a drug dealer because she was from the south side of Chicago and she knew what was going on. So those are some of the facts. She told her client she didn't want to know the source of his cash. She did not handle her client's cash according to the normal course of business at her realty. She did not document the receipt of the money from her client. She did not produce a receipt. She did not deposit her client's payments in her company's trust account. She told her principal broker that a woman from Chicago was purchasing the house, not a man from Cedar Rapids, Iowa. And she did not want to her client told her he did not want to make a payment, a down payment, greater than $10,000 because it might attract the attention of the IRS. So she was convicted. And so my take on this case is not only don't do that stuff, but if you're not sleeping well and you feel bad and you got to get something off your chest and you just got to tell somebody, tell your therapist. Tell your doctor. That's privileged. Don't tell federal agents who are trying to convict you of a crime. And if I'm your lawyer, I want to win. I want the W. So help me out if you're not going to win. Try to help me. Don't tell the prosecutors everything. You've got to tell them facts. You've got to tell them on March 12th I was here, on March 13th I was there. But if you tell them, yeah, I was feeling bad and I knew what I was doing was wrong, you're already lost. So I don't mean to be gloom and doom, but that's at least one example of a broker who didn't do it right. And so if you're not sleeping well and you think you're doing something wrong, you probably are. But if you stay within the lines and you think that you and your client is in compliance with state law, you should be okay. Turn it over to Sam. Thank you.
Just doing introductions.
Yeah.
Okay, great.
Okay.
I was going to have to knock Tom out of here. Is it too depressing? You bolt the doors shut, and it's not an example of a bad deal with a broker. It's the example. Yeah, that's right.
I forgot that Bob Salisbury, he's a great resource if you're really concerned about criminal law. I'm not a criminal lawyer, but we've got resources that can help you out. So if you really do need to call somebody, I can help you.
Thank you, Tom. So, I think we left the room last time with a lot of questions. And we've got people in here that said, why would I ever deal with one of these transactions? Why would I ever lease? Why would I ever sell? What's my situation? What's my liability? And we had a series of great questions, and actually Sam started handling a fair number of them. So we said, okay, who is that guy? We got to get this guy, Sam Chapman, in here for the second round. So to my immediate right is Sam Chapman. He's founding member of New Economy Consulting, a firm based in Portland, focused on advising entrepreneurs and investors on the legal cannabis markets in Oregon. Sam co-authored House Bill 3460, the Oregon law legalizing medical marijuana dispensaries, on behalf of current NEC clients. He continues to work on the development of pragmatic and business-friendly regulations for both medical cannabis and adult use markets. He has been a resident of Oregon for 20 years and holds a bachelor's degree from the University of Oregon in philosophy and political science. To his right, we needed somebody in the banking world that could come and talk to us about this. So we got the guy that, to our knowledge, is one of the best in that field. And I'd like to introduce Randy Blake, who's actually currently not working for a bank. But he had been heading up MBank's efforts in this arena, and he's got 35 years in banking, focusing on compliance, operations, and accounting. Over the past time, he's focused on the intricacies of banking in the cannabis industry. And then to my far right, John Magliana, nationally recognized mergers and acquisition lawyer, general counsel for public and private companies for over 30 years. He also represents cannabis companies, including Oregon's largest cannabis company, which is scheduled to go public at the end of May. So we've got some people that have been working in this field. I think they're going to have some great stories for you. Our objective is to get you out of here not scared to do this stuff, but at least knowledgeable on what to be doing, whether it's leasing, selling, what your liabilities are, opportunities are, and why you should actually consider this. Because I think, like I said, last time a lot of people walked out of here saying, why would I ever get myself involved with this? So I'd like to start off just asking Sam the question. This is not new. As Tom said, it's been around the real estate community. We've been dealing with it since '98. I mean, what's really changed? And obviously, we're dealing with a lot more thought going into it, I think, just with the sheer number of people that are going to be affected by it. But how are things changed?
Right. First of all, I'd just like to thank David for having me back. So since there's a lot has changed, I think one of the biggest things that has changed nationally over the last 5 years really has been the status quo in general. We, as David alluded to, we now have 25 plus states that have some form of medical marijuana legislation. We have multiple states that now currently have legalized marijuana. There are going to be at least 3 to 6 more states coming online in 2016 or soon after for adult use recreational marijuana. And so I think beyond the status quo and people really starting to realize that when we do legalize, when we do regulate, when we do take this product out of the hands of the black market, we see a lot of good come from that. And whether it be tax revenue, whether it be we're actually keeping the drug out of the hands of children better by regulating it than leaving it up to the black market, where they do not ask for ID, they do not test their products, they do not label them, do they not package them. So we've seen quite a bit of public acceptance of the issue over the last couple of years. I think that's the first big thing. The second is we've seen states' rights really take up this issue in face of the federal government saying that there is no medical value to this product, and thus we're going to keep it a Schedule I drug, which is the definition of a Schedule I is it has no medicinal value. One of the questions you may be asking yourself, and maybe John has some insight on this as well, is when is the federal government going to come around? And I would like to think sooner than later. I can't put an exact time date on it, but with the fact that over half of the states in this country now have some law on the books that completely contradicts federal law, they can only take on that black eye for so long. And eventually they're going to want a cut of the taxes as well. So I think the federal government will come around soon. And the other aspect is the fact that there's a lot of money to be made in this industry. The industry itself has made massive strides in professionalizing, in honing in operations, in really, coming to the table not in a tie-dye shirt and flip-flops, but in a suit and tie. And that is starting to change the minds and hearts of legislators and people in government that, oh, wow, legitimate people are getting involved with this business, and now I feel a little bit more comfortable about considering getting into the industry in some form. So I think those are kind of the three main factors that I can see, and I could dive into more detail, but I'll let some of the other...
Thank you, Sam. Hey, John, you told an interesting story, and it sort of dovetails off of Sam's comment on taking the black market out. The people that are involved or getting involved with this industry versus what was there. Can you sort of talk about that? You talked about some executives for companies and some changes that are what's happening there with...
So one of the biggest changes that I see in the industry is, for instance, the company that I represent, one of my clients that's the largest integrated cannabis company in Oregon. The thing that makes that company different and why it works is we have Wall Street executives, Wall Street caliber executives at the top that have experience in business, banking, running substantial public companies in retail, wholesale and distribution, which of course are the key components to making any sort of commercial enterprise in cannabis work. And at the bottom, we have people that have been committed to the cannabis industry for their entire lives, people that are growers and really believe in the medicinal benefits and the other benefits that cannabis can bring to society. I will tell you it's been quite an interesting ride because that bottom level, for whatever reason, there is a disproportionate amount of sometimes tax issues, people that have been in the business that haven't filed their tax returns. So they're waiting to have a tax evasion or other potential tax crime or enforcement action taken against them, especially once they become very successful. My background is a tax attorney, and so for many executives in different companies, that's one of the first inquiries I make. And if they have not filed their tax returns because they've been in a cash business or whatever, then I make sure that they go and we go in voluntarily, no names basis, and work out something with the service so they can then go on with their lives. There's also people have a history of crimes. Many times they've been caught for financial crimes or money laundering and have just continued growing. So there's a lot of issues at that bottom level that make it very interesting, and we learned early on in these companies that we scrutinize and do background checks on everybody.
Thank you, John. So Randy, you had a comment about background checks and whether, when are those, does anyone do background checks on the people involved? I mean, when you're banking, what's happening with background checks with this area as well?
Thank you, David. It's interesting. When we were putting the program together at MBank, we looked at what the state was doing concerning background checks, and when it concerned medicinal marijuana, there was only one person that they actually did background check on, and that was the person that was responsible for running the facility. They don't currently, under the OMMP program, do background checks on the owners of the facility. So, and there were several instances where we confronted potential businesses that hired someone that did not have a criminal record that could qualify as a person running the facility, a PRF, because they couldn't. And so under the recreational use, both in Oregon, Washington, and Colorado, it is my understanding that background checks are going to be done on all ownership above a certain percentage. But to the example that was given earlier about the broker that was convicted in Iowa, that's probably the biggest risk anyone has in doing business with this industry is what they call as willful blindness. Understanding what the transaction is, but not addressing it and trying to do the research necessary to make sure you understand who you're dealing with.
Thank you. So, since we're all real estate people, we want to know how to do deals, right? Got to have some liquidity out there, make some things happen. Some people might not be that busy right now, but Sam, so how do we know if a property is something that's going to fit within the guidelines? And Tom, you referenced, well, you don't want to have this place very close to a school, but maybe if it's the right university, you want it as close as possible, right? So exactly. So Sam?
Right, yeah, so I'll give a little bit of historical background as to what brought us here today, which will kind of give you a little bit more insight as to local and state rules and regulations. So in 2013, as was mentioned in my bio, myself and one other, Jeff Sugarman, wrote the law, House Bill 3460, that legalized medical marijuana dispensaries here in Oregon. Shortly after that, in the February short session in the legislature, the League of Counties and the League of Cities snuck in a bill, basically, that gave, really it was a compromise with the leagues, that gave cities and counties the ability to establish local and reasonable time, place, and manner regulations. So time, place, and manner is pretty straightforward. Specifically the key there for everyone here is what zones are available, right? And so over the last year, a majority of those cities had a moratorium and allowed them to place a temporary ban on the opening of medical marijuana dispensaries. And essentially, that year was the time that the legislature gave them to decide what rules and regulations they wanted to put in place. Those moratoriums lifted 5 days ago, on May 1st, and now every city and county is technically open in terms of the state law. That does not mean that the city has actually abided by that law. Many cities, a handful of cities, are actually still what I would consider quote-unquote closed or developing because they did not lift their moratorium on that date, or they satisfied the law in that they put rules and regulations in place but are holding on to the small fact that their business license, in order to obtain a business license in X city, says that you have to be in compliance with state and federal law. And so this is where we start to get a real snapshot of which cities are saying, okay, we took the time to develop these local rules and regulations. Here they are. We're now open for business, versus the cities who are going to deploy tactics for the next couple of years and probably at some point end up in court litigating this against people who want to open up businesses that say, look, the state law says this and federal law says that, and it's inevitably some of those cities will end up in court. And so I guess as a side note, I'll add that my firm is getting ready to release in the next 2 weeks here a report of the top 50 cities, the most desirable cities in Oregon, with all of the rules and regulations for each city that will help people such as yourselves scrub properties to make sure that they are compliant. You do not want to be one of the few individuals that I know that just looked at the state regulations, said, oh, my property is compliant, I'll sell it or I'll buy it. And then you find out that there are local rules and regulations. I have literally gotten calls from people who have bought $500,000 buildings saying, I did not know that there were local rules and regulations. Do not be one of those people. That's kind of the main landscape in which you need to navigate right now. You know, if you're getting into the cannabis business, your business is politics, and all politics are local. And that is where I see the real hurdles that you'll need to cross outside of making sure that you have the right tenants. Currently, my firm is denying 9 out of every 10 people that are calling us for services. Why is that? You know, a lot of it has to go into what John says. You can't just be on the business side. You can't just come from an industry and have business experience and come to the industry and in a week's time learn everything you need to know about cannabis. And you can't come from the cannabis side, with 30 years of spectacular growing of great products and think that you know how to put together a business plan or even know what a P&L is, right? Businesses that will succeed will have an equal amount of both sides of that spectrum. And that's something where I'm sure John's company that he's mentioned, and as he said, has both of those things. And those are things that we look for in our clients. We vet them thoroughly before we take them on because we want them to succeed, right? We want them to embrace the philosophy that you need to not only do this professionally, but you need to create a Oregon-grown craft product that is going to be, the next Ninkasi, the next Oakshire beer, however you want to think about it. It should be craft, but it should be done with professional, business-savvy sense with a cannabis background. And so that's what I think there.
So it's sort of interesting because last Wednesday I was down on a tour down at Willamette Valley Vineyards and Bruno was down there talking and you don't have to go back very far to see sort of the wine industry in a similar spot. I mean, with the bottle labeling laws and being able to serve samples in stores and just all that growth. And you look at what's happened there, and there was a comment made a while back that when you look at this segment of what could be, you've got the new Economy Consulting, but you look at what this represents, and they say that this region could be the Sonoma, Napa of the cannabis world. That's sort of interesting there. John, you had similar comments to what Sam said with respect to the people involved, the people, the number of people you're turning down too, going forward.
Yeah, well, my background's a little bit different from most of the lawyers in the cannabis space. Again, I'm a mergers and acquisitions lawyer and a general counsel for companies. And so I came at it, I start, buy, and sell businesses. That's what I've done for 30 years. And so those tend to be my clients. I would say most of the lawyers in the cannabis space tend to be criminal defense lawyers that are now trying to, come into the business space and tell people how to grow companies, et cetera. And there's a lot that goes into being able to build companies. That includes access to capital, knowing where qualified people are, those other sorts of things that takes a long time for people to get those resources. I think it's true that you're seeing all different kinds of people come into this space. And the ones that I tend to take on are that they have to have that level of business experience. I'm not going to turn away a pod grower just because the guy has some good ideas. I'm not saying that. But what I will do is, instead of he comes to me and he's been a grower all his life, and some of these people, I'm telling you, are fabulously, $300,000 is not unusual to make a quarter for some of these people. But what I would try to do is pair them with somebody that could help them to understand business fundamentals and to be able to really grow their company and scale it if they want to, right? So I try, again, anybody that knows me will tell you I'm just a perpetual tinkerer. I like to make things grow, no pun intended. And so when I find people, I try to marry them up or get them to the right people that can help them grow their businesses, just opposed to taking on a grower and being satisfied that the guy's going to grow really good plants. And so that's sort of the filter that I have on my practice.
Thank you, John. Randy, Sam hit on, we asked him about, how do you know you got a compliant property? And so let's say you've got one of these properties that is compliant, but it's got a loan on it. What dangers, as Tom mentioned, we've got some issues there with underlying financing, whether you've got it in place or what's going to be available going forward. And I know you're working on some things in that area too. So any comments?
Yeah, so usually what happens is that most of the loans will be identified. If there's a current loan on the property, it's usually a renewal time that when someone comes out and looks at the rental information, the rent rolls, that type of thing, to identify what kind of clients you have in the space. If it gets identified as a property, let me take a step back here and add that you've read in the press a lot about the fact that there's legislative bills in Congress that are going to allow for bank services, both on the deposit side and the loan side. There's always bank services. When we were putting together the program at MBank, once the guidance came out last February from FinCEN, is the database manager for the law enforcement agencies. It gave banks a roadmap to follow, and so it's up to the individual banks to determine, the senior management, the board, to determine if they want to get in this space. So based on that most of them are taking a wait and see attitude at this point in time. But to get back to the loan question, once it's identified that there's cannabis, a renter, or it's leased to a cannabis entity, two things happen. One is usually your loan documents, as you probably are aware, there's a specific covenant in there that says the property can't be used for illegal purposes. It's surprising how difficult it is to program that line out of the software that produces that covenant. So that's one issue that's being dealt with. But then it's up to the individual bank, I believe, to determine what they want to do. Now, what FinCEN has come out and told the financial institutions is that if you want to do business in this space, you can do that. Here's the roadmap. You have to do your due diligence and you have to do your monitoring. And so those banks, pardon me, there's a third piece. If you're not going to do business in this space, you have to state in your policy that you're not going to do business in this space. And then if you identify that you have clients that are in this space, you have to ask them to leave or call their loan. And so that's the issue the banks are dealing with, is that most of them have formally said they're not going to do business in this space right now. And so as loans come due, or as they identify properties, or they identify deposit customers, they have to ask them to leave. So you will find it, as you know, you're going to find it very difficult to find any capital available from a financial institution to finance properties in this environment, because most of them are taking a wait-and-see attitude.
So Randy, have we seen that happen in the medical arena? I mean, have these loans been called and
Yes,
people have,
yeah,
regionally here?
Yes, there are situations that I'm aware of that other competitors, customers have come to us because they either can't get financing or they have to refinance. Usually the banks will give them a period of time to get out from under a loan. They just don't shut it down immediately. But usually they're very upfront. They'll give them a letter calling the loan.
And the scope of it doesn't matter if it's medical or recreational, or, I mean, we were discussing with the broker in the room earlier about even research. Where do you draw the line?
Yeah, that's an interesting, again, it's bank management's determination as to where they draw the line. For example, research, labs, other businesses that provide ancillary products. When we were developing the program, we took the stance that if more than 50% of the revenue from the business is generated from cannabis, then it's a cannabis direct business. But if they offer services that go outside of cannabis, and cannabis was just a portion of their business, we determined that it was not cannabis. Now, when it comes to the monitoring, we still monitored all of the accounts if they were involved in cannabis at all. So that wasn't an issue really for our purposes.
Okay, great. John's really excited.
Yeah, I'm really excited because, Randy, that's interesting to me. So let's say I've got a business that I've got a client that owns a nice 60,000-foot warehouse. And the 60,000-foot warehouse has been used for manufacturing for a number of years, and the manufacturing company decides to go out of business. The family winds it down, and the owners are looking for something else to do, and they sure would like to go into marijuana because they can get double the square footage of the rental space. So what's going to happen to my account, Randy, if that's my sole asset, that warehouse, and now I'm leasing to a cannabis company? Well, if the financial institution finds out that you're growing cannabis, then there will be issues. But again, the interesting part is it's all about transparency in the industry. But yeah, I mean, in John's example, the loan would probably be called, and they'd have to find financing elsewhere.
So you were talking about the refis when they're going to be snooping around, looking and checking things out. But for the bankers in the room, most of you, I believe, want the relationship these days. So you probably have the loan on the property and the company's banking too. So all of a sudden we've got deposits coming in from, and actually John's got a comment about what you name these companies too. But it's possible that would bring it up way before renewal also. I mean, if you're banking everything through that lien holder,
Exactly.
it's going to be a problem. John?
One other related point, though, that I want to make sure everybody knows today, because this happened to me with a client. So you've got a client that's got a distressed property, bank-owned, and a cannabis company wants to come to buy it. And the owner would love, and did in my case, run to the bank and say, there's going to be no foreclosure, we're selling to a cannabis company. You may think that the bank would just go, that's okay, we're going to get our money and get out. But guess what? The bank accelerated. They were a candidate for foreclosure, and now we're under real pressure to get that loan closed and to get the sale done. So, distressed property, cannabis buyer, don't run to the bank. Just finish your transaction. There's no reason to tell the bank who your buyer is. It's a cash deal. Be gone.
Well, was the broker involved with that one, the one Tom mentioned earlier?
Oh, yeah, the lady that moved to Chicago.
Yeah, exactly. I think maybe so. So we hear all these things, you shouldn't do this, shouldn't do that, your loan's going to be called, and all this other stuff going on. Sam, why should someone consider selling or leasing to somebody in this business?
Right. Well, I think John hit on one of the main points, which is that right now you can get far above market rate for a lot of these spaces, especially when it comes to leases, obviously. I would say at least, and this number is going down, but at least 90% of the people who are looking for space right now are looking for leases. And so, that's one of our stipulations on our checklist when we're vetting potential clients is, are you looking for a lease or are you looking to purchase? And if you're looking to lease, we say, here's someone else. Because basically you get into a bidding war and you're going to get up to somewhere, I think average lease rates for something around, 1,000 to 2,000 square feet can be between $5,000 and $8,000 a month right now. So maybe that's one more reason everyone's thinking, holy shit, maybe I should lease to a dispensary, right? I've got clients that'll pay it, but we don't really take on lease clients anymore because, whether it's, maybe they have a note, right? And the note is something to be of concern, right? If a landlord, I'm going through a deal right now with a landlord who owns a property outright, and his attorney, unfortunately, is not John. And has scared the living hell out of this guy because he's told him, look, asset forfeiture, you can get everything taken, you could go to jail, you could go to jail, you could go to jail. And so we're having to debate with this landlord's attorney and show them, look, here's the Cole memo. Amanda Marshall, who is now retired, is no longer our federal attorney general, or not attorney general, state's attorney, I guess, right, John? Is
right.
That, yeah, right. Said, after we passed 3460, that law now makes Oregon comply with the Cole memo because it's robust. If it's a robust regulatory system, they don't have the time or the manpower to come into a state and bust just anybody, right? You need to be selling drugs to cartels, selling drugs to kids, crossing state lines with marijuana, doing really shady, stupid stuff like that woman did in Chicago. Those are things that you really need to be watching out for. If you have a property that you own outright, you're going to be fine for the most part. I'm not an attorney, so I'm not going to give legal advice on that, but it's really a lot less to worry about if it's not bank owned, there's not a note, and you own it outright. There are going to be a lot of attorneys that simply have not looked into the issue as much as John has, right? And they're going to tell you, well, let me see how many hours I can clock onto my research and see how many scary things I can bring up, and I'm going to show it to my landowner, and that's going to be it, and it's going to be a no-go, right? So a lot of it comes down to attorneys that really are kind of just profiting off of scaring their landlords out of it. It's unfortunate because I think there'd probably more money for the attorney in actually allowing it and helping them navigate rules and regulations. But, in terms of if you've got property for lease, property for sale, and, you would like to entertain a cannabis business, let me know. I can help there. John?
Yeah, so hold on a second, John. I was just going to say, so now you got all the lawyers mad at you, Sam, but
That's okay.
all right, that's all right. So
John's
I
not mad at
just
me.
want to point out the last bullet in Connie's memo talks about leasing, and that's where I was going to go with John next. So you're probably jumping in on it, but you did a nice job on that, Connie. So thank you, and you can all look at that. John, you had your first deal was lease issues when we talk about questions and things that they need to be involved with. So for the brokers or the property owners in the room, you know, you've got breach of standard lease at signing. I mean, what have you seen? What have you done? What is, and obviously you're working from the tenant side probably more than the property owner side, but you can look at it and say, hey, what do I need to do to take care of, if I'm a broker in the room, what do I need to do to take care of my property owner?
Well, there's a number of things that you can do. Before I say that, though, I did want to make a comment about lawyers. A lot of lawyers are trained to, and we all are trained to find problems, okay? And many lawyers do focus only on the problems and not the solutions. I think a successful lawyer focuses on solutions for their clients. Yeah, you got to point out the problems, but the problem should not be the focus of a business relationship. The solution should be. And so for all of my clients, my philosophy has always been to provide them with the information they need to make a decision, because they're the ones that have to live with the decision, not me. And what you can do is you can provide your clients with the benefit of your experiences and what the state of the law is, and give them practical information that they can then use and put in their own risk aversion grid. Some people want the money. Some people, you know, unless you're have never had a tax lien filed against you, you're not a good candidate for the property. So we've all represented people on different ends of the spectrum. Okay, so having said that, and there are a lot of lawyers that just say if it's cannabis, you could lose it, and then their clients are scared and they don't come back. So I have a number of things that brokers should look for with leases. We talked about the breach of the standard sort of provisions at signing. You know, it must be for a lawful purpose. And so if you sign the lease, you're breaching the lease. And so the first thing that you want to do is address that. So all my leases say, for instance, that it's specifically acknowledged that this property is going to be used for cannabis. It's going to has to comply with the Medical Marijuana Act and laws. And so by addressing it that way, you're not violating that clause that said the property must be leased for all and comply with all legal purposes. We've talked about bank financed properties. It's obviously easier to do things on properties that are owned by individuals, and there's no bank finance, because then you don't have to worry about the call from Randy or the bank there. Some of the other issues are if I was a commercial, and I do represent landlords and building owners, I would think seriously about prohibiting any butane use. Butane is used to make hash oil, if you didn't know that. And it's also used in other processes. It's extremely flammable. If you turn on the news, you can see that there's a lot of problems with explosions that can damage the property, can kill people, can have severe burns. So I'd think about, if I was a landlord or someone renting, limiting butane or excluding it. There's in some of my leases that I negotiate, I would say this is pretty standard in the cannabis business, the security deposits tend to be higher. And the reason for that is, depending on who I represent, and you guys can see both sides of this, right? But I'll talk to you from the tenant side right now. If I'm worried that there's someone that's entered into a lease before May 1, and we know what the cities are doing at the local law level, and I want to lease because this is a great property, what if the law changes now and I'm zoned out and I can't use my property? Well, I've had some landlords, if I put down like 3 times 3 months worth of security deposit, if the law changes so that I can no longer do business there, I'll forfeit the deposit gladly to get the heck out of Dodge so that I can go somewhere and conduct my business, okay?
So, John, we got a lot of multifamily people in here. You've got, comments about smoking prohibitions
That's a great
and what happens there.
That's a great one. So this comes up a lot. So you've got apartments, for you apartment builders here. You got a guy calls up the landlord and says, I need a reasonable accommodation because under the American with Disabilities Act, I need to use my pot and I'm disabled. And you have a no smoking policy here, or no, it's in my lease. So I want a reasonable accommodation. Well, the answer for the landlord, if you didn't know, is the ADA is, by the way, it's a federal law. And the courts have specifically held that smoking marijuana does not need to be accommodated. Okay? So that when the tenant comes and says that, you don't need to do it. Now, that's the legal answer. So this is kind of what I get into. Is that the right answer? I don't know. Because some landlords, some people might like that. Maybe that tenant is the best tenant that you've got, or a group of tenants. So reasonable accommodation could be a separate agreement with them where we talk about reasonable restrictions. No smoking outside your apartment. We're going to put a fan in and you have to pay for it. You know, make a decision about whether do you want them to be able to smoke the leaves that happen to smell like skunks, in my opinion, or a vape pen, some kind of pen that's very difficult to detect if it's not flavored. These are the kinds of things that you can go through and accommodate people so that you get to a reasonable business decision. Okay? I would point out, though, another reason for having higher security deposits of people that smoke is that some of the smoke, and for even residential dwellings, if they're growing and you don't mind it and it's legal, the smell can permeate drywall and things. So there could be some additional remediation after the tenant leaves in order to protect the value of the property. So those are some of the considerations that you'd have for people that want to smoke.
So how about, you have this incredible security apparatus that you have to have as part of the dispensary package. And so, we usually recoup our tenant improvement dollars over the length of the lease, but like you're saying, it's a volatile situation, it could end tomorrow. Are you seeing that the tenants then are paying for all of those improvements? And then what happens if they do have to leave? How are we going to get it back so it's a functionally usable building without all these attributes being attached to it?
The answer is, so I have this saying that I use, it's called managing people's expectations. And I think that everybody should everything should be on the table in a business relationship. And then let's discuss them so that when we're done, we all have an understanding about how things are going to work. And in that case, see, in my opinion, the solution is the increased security deposit. You have to look at what is your exposure as a landlord owner. And if it is, and you're hearing in the industry that when people are moving out or they're going out of business unexpectedly, that you're being held with unpaid rent, that you have issues with remediation of the building to be used for other purposes, that needs to be reflected in your economic agreement with the party.
And one quick thing to add to that, because you said dispensaries specifically, by law, there is no smoking on premise allowed in dispensaries unless, and this is one small caveat that not many people know, you are an employee and a patient. You can smoke by yourself in a room, which is weird. Because if you actually need medicine, like doing it by yourself in a room could actually be a bad thing. But just a side note that right now there's no specific law allowing people to smoke on premise at dispensaries. You've probably heard or maybe have seen the marijuana lounges that operates in a gray area of the Clean Air Act, I think, because that does not apply to marijuana. It only applies to tobacco. We are seeing a lot of really interesting vaping legislation going through Salem right now. I'm also a registered lobbyist, so I'm down there half of the week. But right now, if you have tenants that are smoking on premise that are not patients and employees, you can just tell them, no, that's not allowed.
By the way, we'll open the floor up to questions in about 10 minutes, so if you've got them, they won't be left unaddressed, hopefully.
One last question, point though on
You
smoking.
can't ask either.
No, I'm not asking.
They got to wait.
One last point on smoking. If you have existing leases and it says no smoking on the premises, you're okay with marijuana, all right? If it says no tobacco smoke, you're not, and you need to do something about it. So take a look at your leases. If it's a problem and you want to ban smoking altogether, then you're going to have to make sure that it's generic or that it specifically says no smoking of tobacco or marijuana or anything else.
I wanted you to make that point. That's a good point.
Okay.
I'll accept that. So Randy, let's say, so Sam says the property fits, John's got a lease that works. Now, how do you bank the lease payments or, or not dispensary, but the business that's there? I mean, how do they get paid? What happens with the money flow? What specifically, what can you do, what can't you do? What's going to get you in trouble?
Well, the first thing that will get you in trouble is if you try to hide what you're doing. As was pointed out earlier, if the comment about not making a deposit or a down payment greater than $10,000. If you, for example, if you're client receives a lease payment that's greater than $10,000 and they attempt to deposit it at multiple bank accounts at different banks, that's called structuring. And you won't get arrested for marijuana, but you could get arrested for money laundering.
So what if your lease is just bi-monthly payments?
As far as the amount?
No, instead of having it, I mean, you're paying X dollars a month,
Oh.
but it's structured to be paid.
It's
Bi-monthly.
interesting. Yeah, so if the payments are structured, if you structure them that way, the role of the financial institution, they're only a data gathering tool for the Department of Justice. If the deposits are greater than $10,000, a report has to be filled out. If the deposits are made in such a way, if they're bi-monthly and it's cash and it smells like marijuana, then you probably...
It's a serious problem for a lot of people.
Yeah, it is a serious
Believe it or
problem. Although people are learning, they're now segregating cash from the rest from their product. So, but you have to fill out a suspicious activity report, and so those are the two primary tools that the banks have to go through and the credit unions have to go through in reporting these kinds of transactions or their suspicions of these transactions.
So if I'm the property owner, I get this payment, and let's forget, I mean, it's 20 grand a month, it comes in, and you mark on there that it's suspicious activity, and what does that do to me?
What happens with the information is the banks complete a report, or whether it's a currency transaction report or a suspicious activity report, it gets electronically sent to FinCEN, which is the Financial Crimes Enforcement Network. And as I said, that's just a huge database. It accumulates all of the data from all the financial institutions, all the money service businesses across the United States, and they slice and dice the data, and then they will send it to local law enforcement. They'll send it to the IRS, local law enforcement, DEA, and it's actually up to those agencies to determine whether or not they want to investigate.
And if they investigate, what does that mean?
That means that they could contact the bank and ask for more information, which they can do, but they have to subpoena the information. We don't have to readily give it to them without a subpoena. And they just carry on their investigation. That's separate from the financial institution. A lot of people think that the financial institution is the one that will do the investigation, or that they're the ones that will seize the property or seize the accounts. It isn't. They may be asked by the Department of Justice or local law enforcement to freeze accounts or to seize property assets that are at the bank, but it's all driven by local law enforcement or other law enforcement.
But if I've got a debt-free property and I'm just taking these lease payments and it's legal here, and they what do? Put a little mark on my account, say suspicious, and it really don't have anything to do to me, do they?
They can. Again, it depends on the institution. If the institution does not have if they've said that they're not going to service cannabis, then and they believe that the cannabis is being grown on a property and they're taking deposits related to cannabis, they have to make a determination as to whether or not they will keep that relationship.
But you've got the background in this banking world, and I know you're working on other things. I mean, obviously, this is happening. This is being done. So going forward, you're going...
So,
I mean, I know you can't talk a lot about what's happening.
What I would
but
say is that as I started doing work in this space, the statistic or realization that I came to was that, and it's proven out, is that probably 80 to 90% of the customers that we were talking to once we got our program up and going already have bank accounts. The problem is, or the issue is that the institutions that they're dealing with don't have programs in place to identify their accounts. And so that is an issue that the industry will be addressing in the future, because that puts them at risk. Because if they're found in non-compliance, Bank Secrecy Act, it is one of the few regulations that if a institution is found to be non-compliant, that the regulators can shut the doors. regardless of how successful the bank is. Now, to my knowledge, there's been very few institutions that's occurred. Usually they get fined, and they have to fix their program to bring it in compliance. But that's what's at issue. So.
But if I were to put, I've got a business that deals with investments, and if we said, gee, we're going to put a fund together that's going to finance these purchases of properties, and we do that, and we're not sort of, cuffed by the FDIC or anything else. I mean, what potential issues, so I'm the property owner, I'm getting the payments, they're coming in, like I said, it's sort of a blemish on me. It allows them to investigate me. Maybe it costs me some money. My Dale back there is angry, or actually maybe he's happy because he's got hundreds and thousands of hours now to bill me for keeping me on the straight and narrow. But what's the ultimate repercussion there? I mean, could the government, and it's probably a question for John too. I mean, could they come in and say, gee, this is federally against the law. We're going to take the property.
My response would be that if you're following the program, if you're doing what you're supposed to be doing according to FinCEN as well as the state of Oregon, that the probability that someone would come in and seize property is very small.
Right.
In fact, we actually had an attorney do some research in Colorado, Oregon, and Washington to do research to see how many times has a property been seized due to illegal drug activity specific to cannabis, and there was one in those 3 states. And so I think the premise is that if you're doing what you're supposed to be doing, then the probability is going to be very small. And in fact, most of the issue from a financial institution's perspective is that I don't think they're as concerned about seizure as the cost of getting the property back. Because the federal government, Department of Justice, they'll come in, they'll seize everything, and then it will be up to the bank to reclaim that property. So there's lost opportunity costs there with attorneys and lost revenue from losing the property.
Yeah, so I mean, we've got 17 years almost of time in this, really, since medical came out, right, in this region. So we're not dealing with a new issue with the banking. And from what I understand, there's no credit card use. It's pretty much all cash, right? All the income, the tenant, all the banking to the landlord, everything is all cash. So the biggest issue is securing things, it seemed like.
If I had to guess, I don't know the specific case that you're referring to, but if that seizure probably had to do with someone who was blatantly breaking Cole memo laws, right? And maybe John could correct me if I'm wrong here, but there have not been seizures of property just because that property was dealing with a federally illegal substance. There has to be so much more than that for FinCEN to send it to the agencies to decide what's going on. I mean, that agency has to investigate, at least in my knowledge of the raids that have happened in the past, that those people are at least under investigation for no less than 18 months. And that investigation is criminal. To my knowledge, has nothing to do with the real estate. The real estate is just something that is on the side of it that is much a wart of the much larger problem of this person is illegally trafficking marijuana. They're part of a cartel. They're dealing with guns. They're selling it to kids. They're transferring it across state lines. Those are the things that if you're a property owner and you get dragged into that mess, that is when you should have real concern. I don't know if there are any other examples of a property just because it was dealing with cannabis business getting forfeited. And even if it were to happen, asset forfeiture law in Oregon says now that it's been reformed, you have to be convicted of the crime for them to keep that property. Is that correct?
I'm not.
John? Okay, no, sorry.
These guys.
Okay,
Right.
so John, I've got one last question.
Just one closing point.
Sure, Randy.
Is that what I'd also add is what you hear when you hear about property seizure, most of it occurs in California.
Right.
And the reason that is California does not have a statewide program. So they don't have the same structure that Oregon, Washington, or any of the other states that have passed statewide legislation have, and that's where you hear a bulk of the property seizures.
Thank you. So John, one last comment, and then we'll open up the questions from the floor. So realtor disclosures for leasing issues or purchase and sales.
Well, you guys are required to disclose anything material that could affect value or use of the property. And if there's people using marijuana on there or marijuana tenants that will stay afterwards, I know that you're all disclosing that to potential buyers. Because if you don't, that's a problem for your license. Not so much a legal problem, that's just a realtor problem.
So as far as any realtor aiding and abetting issues that might exist too?
We have a memo on
Yeah.
that, I believe, but because we had the Chicago case that we talked about, but if realtors are knowingly helping people to set up grow operations or processing in marijuana, there is a technical legal argument to be made that you are aiding and abetting a criminal drug enterprise, all right? There's one thing I wanted to make a point on that nobody's talking about in the Cole memo that does concern me only because of the size of the clients, some of the clients that I have. And that is that there is an exception in the Cole memo for when something becomes a large for-profit commercial enterprise. That's one of the exceptions that they say that they reserve the right to look at you. I don't know what that means, but some of these businesses are getting large. And so you need to think about it as well.
So sort of on the flip side of that, though, we've had discussions about, like an apartment building's nice, you've got diversification, you've got all these tenants, you've got stability there, right? So we've talked about operations where instead of having one tenant, you slice it up, you got a series of tenants.
That's a great one. So one of the other things that I advise people about, so you go out and you buy, or you want to sell, buy a 100-acre property. And the idea is, this is a great way, cannabis. I'm just going to go out and I'm going to rent, have 10 different cannabis clients here. They'll take all 100 acres. I'll have the thing paid for in no time. The problem is, my perception and what I have seen is that for each different tenant that you take on, you're increasing your exposure. And what that means is, if we knew for a fact that all 10 of those were going to be good citizens and use good lawyers that would advise them of what the law is and that they would comply, that's great. But as you increase the number of tenants on a property in the cannabis business, you're increasing this chance that some or all are not doing that. Then the scary thing for the landowner is, well, if the feds come to bust one of these guys for being the egregious user, while they're there, they might just as well take everything. Is that a high probability? I don't think so, but when you're talking to clients and you're trying to, again, manage expectations, these are the kinds of things that you start to do, you weigh and balance. So that would be one on the negative side, right? The fabulous amounts of money that you can make and have the property paid off faster, and then you can own this property free and clear, that's on the other. And so you go back and forth on all these issues, and so all we're trying to do is expose you to a lot of the different issues you should be discussing when you run into potential cannabis clients or transactions.
Thanks, John. We have any questions from the floor?
I have heard that Colorado set up a state bank for deposits for cannabis business. Is that something that Oregon or Washington are looking at? Can you repeat the question?
Colorado establishing a state bank, you said, for deposits from the business.
So I'll go ahead and address that. So yes, there's a movement in Colorado to, and it's been advertised, an institution by the name of Four Corners Credit Union is in organization. And it'll be an interesting test for the financial system because their focus is going to be cannabis. We've been told by our regulators that, banking is a risk business. And we don't understand, the people that I talk to, how they could allow a credit union or any financial institution to open up and focus on just one industry. We don't believe that that's going to be allowable. And in fact, they've been waiting, I believe now, for at least 8 months for the Federal Reserve Bank to issue them their bank number. And for some reason, it just has not been addressed yet. When it comes to deposit services as well as loans in financial institutions, the business is what our business as working in a bank is risk management, and I don't believe that the credit union in Colorado is going to succeed. I don't believe that the same thing will happen here in Oregon or Washington. I think what will happen is as more water flows under the bridge, that more institutions will start getting involved in this. Once it becomes, and if it gets off Schedule 1, so it's not federally illegal, I think that will go a long ways towards moving the industry forward when it comes to services.
Thank you. Connie?
I could add just a couple of comments. First of all, when we wrote our article, we called Gene Bentley with the real estate agency, and his view was also that it's primarily a disclosure issue for real estate brokers. And I'd like to give an example or an analogy because I think it helps eliminate some of the intimidation. Bob, I'm going to pick on you because you're the one after the last meeting to say, I'm terrified of this and I don't want to have anything to do with it. I'd like to relate it to all of my presentations to this group about security, right? When we're talking about selling real estate and raising money through securities, you say to me, Connie, I don't want to have, Bob has said to me also, I don't want to have anything to do with that. And my response to Bob is, you should not be afraid of it. You have hoops to jump through, and you need to put together the right team to jump through those hoops. And maybe that's hiring John and Adam and Tom or our firm to make sure that the team is the right team for doing this appropriately so you're not totally on the hook. Same thing with the marijuana laws. You need deal-making lawyers, not deal-killing lawyers, but you need to have that team that is experienced so that you and your tenant or landlords can do it right. And the other comment is, this was really interesting. I sat down with Joe Sandahl, who you all know. He says, Connie, I'm looking for space for my manufacturing clients, and I cannot find one space because they are all taken up by marijuana clients. So the people in this room need to be helping their clients create industrial and manufacturing space for all of those non-marijuana clients who can no longer get that space.
Thank you.
That's
John?
a really great point, because one of the points that you don't have time to make them all, is what we've been able to watch, what's happening to the market, because this marijuana influx of entrepreneurs wanting to get into this space, they're also driving up the rents for non-marijuana users, and there's a shortage, so supply and demand, right?
Matthew, you had a question?
Yeah. One of the things that's going through my mind as I hear about this topic in this industry, although the medical marijuana dispensary is not a new business, these are all essentially startups. So landlords who are going to service this industry are dealing with a startup. If it's 20,000 square foot of industrial, if it's 3,000 square foot of retail, the question going through my mind, is there really the demand component? Much like the coffee kiosks of the 90s, and there's Dutch Brothers and Starbucks back dominating that market because the others have folded.
Right.
So the landlord has to be thinking, gosh, if I get this building back with 20,000 bales of marijuana in it, what am I going to do? Right? What are my risk propositions?
Right. Well, if it's a dispensary, you can have unlimited product on premise. I'll give you that one. So that's one creative thing. But in terms of, one of the main questions I get from a lot of people is, how do I enter the industry? How do I, medical doesn't sound profitable. How do I just jump into recreational? And I say, I'm sorry, that's not how it works. In Oregon, you need to get into medical first. And there's several reasons for that. The main reason being that it's very, very, very likely that existing medical marijuana dispensaries that have been licensed in Oregon will be given first crack at recreational licenses, right? They've already been licensed, they've already been inspected, they're in general good actors. And if you're the state and you have an interest in collecting as much tax money as possible, you want to convert your customers to tax-paying customers. Medical marijuana patients will not have to pay a tax, nor will many of them, in my opinion. I think at least 75% of all patients will not renew their card once they can go into the dispensary. And then there's an argument from Colorado that says, well, it's actually stayed the same and increased in Colorado. Well, that's because they have much higher taxes than Oregon is going to have on the sale of marijuana. And so they wanted to avoid paying taxes in Colorado because they were so high. Our tax structure is low. And in fact, our legislature, that was one of the first things that they learned out of the gate, that we have one of the most robust black markets in the country. 90% of our product that's grown right now in Oregon is leaving for New York and Florida, right? It costs them $500 a pound to produce here, and that's on the high end just to produce it. It's selling for $7,000 on the East Coast, a pound. I don't think you should get into that racket, but those are the types of things. So, getting into medical, you got to just plan to stay above water. And really, I mean, you know, right now there's one dispensary for every 50 patients in Portland. Portland is saturated. You really need to be able to buckle down and have a decent amount of capital and know what you're doing if you want to open a store in Portland right now. If you really want to be in Portland, I would suggest you partner with somebody. But there are other cities that are opening up that just lifted their moratoriums that have 0 dispensaries, and the regulations are there, right? And that's where, in my opinion, the opportunities are going to be.
Thank you. Brent?
Sam, is there anything at the federal level right now with the House working on a bill? I mean, if you've got 3 states now for recreation marijuana, and then you have 25 states using it medically, what are they doing?
Right. So they've been proposing and introducing bills on the federal level to change a lot of stuff for the last 5 years. None of it has really gained traction. The most recent issue, they're still, you know, really trying to bite off on this is medical, right? A bill to allow VA doctors to recommend medical marijuana for veterans that failed a couple of years ago by about 30 votes, failed again this year, just last week, by 3 votes. So the federal government is making strides, right? And I really think that, you know, another one of the main questions that I get from prospective investors is, what happens if we get a super conservative president? What happens if, you know, Chris Christie gets elected? And he's publicly said multiple times, I will crack down on marijuana users. I say, I would invite you to do that, because in my opinion, that's political suicide. I mean, the cannabis issue is no longer partisan. You know, if Republicans were to come out heavily against marijuana or any of it, they alienate the other bases, libertarians, Tea Party, right? I mean, and that's a killer in politics, in my opinion, for, you know, the conservative right, you know? And so I really think that those type of dynamics are really starting to allow us to see the transition in politics in general at the federal level. And once that starts happening, once they start seeing, oh man, there's real cannabis contributions coming to my campaign, right? I mean, the money isn't just being spent on, you know, whatever marijuana entrepreneurs spend their money on. They're reinvesting it in politics. And that's one of the smartest investments you can make if you're a marijuana investor, is investing in the politics, right? One of the mottos we have at my firm is, we write the laws to fit the business, right? And if you can do that at the federal level and the state level, you've got something good going for you.
Thank you. One last question. Kevin, you asked one earlier. I'm going to get the guy in the back. These guys will stick, you all 3 stick around afterwards for questions. We just need to get the room, get people where they need to go.
Cannabis transactions boomed out. I got an office condo for sale downtown Portland. Listed as office use. Buyer shows up, wants to buy an investment property. It's only about a $260,000 deal. We asked him point blank, we asked the realtor for the buyer, what's the use? Is it marijuana? No, general office use. Accept the offer, get into inspection conditions period of the offer. And without alerting the listing broker, the buyer sends a letter to the HOA for the condominium building saying, I'm escrow to buy this property. I want to open a marijuana dispensary. Will you approve the use? So then we get the letter forwarded from the seller, all kinds of ticked off because this wasn't disclosed going in. We confront the buyer's broker who says, I wasn't really comfortable with it, but we asked around the office and they said, go ahead, you know, he doesn't need to disclose at this point what the use is. So now we've got the buyer that still wants to try to buy it, the seller that still wants to sell it, because he just wants to get out of it. But the HOA board doesn't want anything to do with it. And so then the seller is mad that it wasn't disclosed initially and wants to try to collect the earnest money and keep it, even though we're still in the general conditions kind of review here. So, I guess my question is
That's why you have lawyers,
Super performance.
And that's why you have lawyers.
Well, first of all, I'll just tell you this, I think that's a lesson for everyone to be learned. If you're trying to qualify your property about who's gonna buy it and what they're gonna do, get it in writing, because then it's fraud, bud. Yeah, and then you can vitiate the contract, so, but that's why they have lawyers, that's a good one.